Hello, John Dove here, and welcome to the latest episode of the Speed Mooting Podcast. Today we had a very interesting episode. We answered some of your questions, and you sent in some very interesting questions today. I discussed the procedure for a trial in the Crown Court. Hayley spoke about the subject of billing for commercial solicitors. We discussed a film that we watched recently, a John Grisham film called The Runaway Jury, and it was quite an interesting topic because we discussed the subject of jury selection in the United States and how that differs to jury empanelment in the UK. And then we finished by talking about our plans for the weekend. So we enjoyed recording the episode and we hope you enjoy listening. Welcome to the podcast. Hello, welcome to the next episode of the Partners in Crime Speed Mooting Podcast. I'm John.
And I'm Hayley.
And welcome along.
Welcome.
So for those that don't know, we are the Speed Mooting team and we discuss all things speed mooting.
Funnily enough.
So we talk about what we do here at Speed Mooting. We talk about our background because we're both lawyers, aren't we, Hayley?
We certainly are.
And we talk about other general nonsense as well. So we start every episode by naming the episode, and we name it after an athlete with some connection to the number based on that episode. So this week we're on episode 18.
Wow.
So Hayley, how many weeks have we been recording?
17 weeks, John.
17 weeks. She's getting good at maths. So episode 18, that makes this the Lance Stroll episode.
Lancey!
Yeah, pretty solid driver. Drives for Aston Martin in Formula One. Mm-hmm. I think he's had one pole position, and I'm pretty sure it was Turkey 2020, which was the rain-affected Grand Prix.
Okay.
So if I remember rightly, I think that's the Grand Prix where he got pole position. Also had a few podiums as well, so pretty solid driver.
Nice.
Significance for us of his name.
Yeah.
There's a road not far from us called Lance Lane that we walk up, and we stroll along it. So, we go for a Lance stroll, if you'll pardon the pun.
Sometimes for sure we'll just say, let's go Lancing.
Let's go Lancing. It's become a verb.
It has.
So that's him. Honourable mention for the number 18.
Go on.
Wayne Rooney during his first career at Everton.
Wayne Rooney.
I think we mentioned him during the number 10 episode. But
Did we?
I think so. I can't remember.
It's been that many athletes now, John. I can't keep track of them.
We can't keep up, can we? So,
no.
Welcome to episode 18, the Lance Stroll and Wayne Rooney episode.
Welcome.
So,
what's on the agenda today, John?
Well, I think we're going to start with some questions, Hayley.
Oh, okay, great.
So we've had a few interesting questions coming through. So I'm just going to refer to some of the questions that we had through.
Yep. While you're having a look, I'll just let our audience know that you can send your questions in to us any way you choose, by email at info@speedmooting. You can comment on one of our posts, so we're on every social media platform that exists pretty much, I think.
Pretty much, I can't think of any that we're not on.
No, so the hashtag that we like to use is AskSpeedSquad.
Yeah.
So send in your questions to us and you'll find them being answered on the podcast.
Absolutely. So, the first question is, how easy is it to attend court and observe?
Let you take this one, John?
Yeah, this is very much in my wheelhouse, isn't it? The short answer, very. So, all courts, with the exception of very few, so for example, the youth court, the Crown Court if it's dealing with a bail application, something like that, all courts are open courts. You can go to court and sit in the public gallery. And if you're an aspiring barrister, if you're an aspiring solicitor advocate, if you aspire to be any form of lawyer that conducts advocacy, I would highly recommend going to court and observing some advocacy. So have a look for your local courthouse. Doesn't matter what it is, whether it's a civil court, a family court, a criminal court, whatever. Go along and watch some advocacy. So obviously go to court. Look for someone in a gown walking around with a clipboard. They are the ushers. They are arguably the most important people in court. Introduce yourself to them when you see them walking about in the general area. Introduce yourself. Let them know that you're a law student. You want to see some advocacy, and ask them if there's anything interesting going on in any of the courts. They'll let you know. They'll bring you in and sit you down in the public gallery, and it's amazing what you'll have the opportunity to watch. And so What I would say is, if you have a morning off from university or the bar course or whatever it is that you're on, take the time to go to court, sit in the public gallery and observe. If you go to the Crown Court, for example, you can watch pleas and mitigation, you can watch openings, you can watch witness handling, and you're going to see, some of the top advocates in the country performing witness handling. Obviously, if you go to the civil court, you'll get to see the practical side of what it is that you're learning in your civil litigation modules. So some case management hearings, maybe even some trials in there, some general procedural applications. So highly, highly recommend it. It's a great opportunity to watch some advocacy and, of course, network as well.
Definitely. And I would just add as well, even if you're not an aspiring barrister or advocate yourself, I think it's still really important to get some courtroom experience, because even as commercial solicitors, and especially if you're litigation as well, your clients will ask you all the time, well, what's going to happen? What's the process? What happens in court?
Yeah.
And if you've never stepped foot into a courtroom, if you've only ever sat behind your desk, you'll be like, well, I think this is what happens. And it's very different to what you read in a textbook, actually getting some courtroom experience. So I would say, even if you don't want to be an advocate yourself, it's still really useful to get yourself into court.
It's crucial to know. It's absolutely crucial to know. Given a practical example of that, when I was at the Crown Prosecution Service and I was doing review work, so for example, when I would give charging advice to the police, so the police would send a file of evidence to me, I would review it, and then I need to authorise the charges, say, which charges are made out, etc. Given that I had previously acted as an advocate for so long, I understood how these cases would go in court, what would happen, how the evidence would play out, and can therefore make a practical decision on that. So having experience in advocacy, knowing what goes on in the courtroom, that guided my decisions and meant that they were much more solid decisions, in my opinion anyway.
Yeah.
And likewise, for general litigation solicitors, knowing what happens in the courtroom, knowing the procedure, that can certainly help you in your day-to-day practice. So completely agree there, Hayley.
Yeah. And it's just a way to build up your confidence of being in that environment as well. I remember when I went the first few times as a student, I was really nervous, and I was only there to watch, but the courtroom can be quite an intimidating place to be in.
Yeah.
So the more you get yourself down there, the easier you'll feel, the more relaxed you'll feel in those settings. And again, that's really important. I'm just speaking from a commercial solicitor point of view. When you go and you're there with your client, if you're there feeling really nervous and intimidated, then how are you going to put your clients at ease when they're the ones that are going to have to, give evidence at trial, etc. So the more you go, the less scary the courtroom feels.
Definitely.
Like, I bet you don't even, you just walk in and out, you don't feel any ounce of nerves there. Is it a second home for you now?
Yeah, pretty much. Yeah, you've settled in. Obviously, when you've got a big, I say this all the time, when you've got a big piece of advocacy to perform, you still get the butterflies just beforehand, so, a meaty closing speech or something like that, you still get them beforehand.
Yeah.
That's the adrenaline. But yeah, the actual walking into court, it's what it is. It's all part and parcel of the job now.
Yep.
Right, so we've had a second question, and this is a question for both of us.
Ooh.
So the question says, Hayley and John, how did you find your specific areas of specialism?
Oh, okay.
Okay. I don't know if you want to go first.
Yeah, sure. So my area of specialism was property litigation. So ironically, I didn't really enjoy studying property too much at university. I scored well in it. So I had that little thing in the back of my head, like I scored really well on these types of areas. And then I worked as a paralegal for a high street firm during university. So my law degree became a 4-year degree, so law with a professional placement. And that high street firm was property litigation.
Okay.
It was mortgage repossession type work that I was doing. And I went back there after university. They were acquired by a subsidiary of Irwin Mitchell. So that's how I became part of the Irwin Mitchell group.
Real?
And me, as a wannabe trainee solicitor, was like, come on. Because suddenly I went from a very small high street firm to being part of the Irwin Mitchell group, which meant I could apply internally for their training contracts. Well, fast forward a bit to me starting my training contract with Irwin Mitchell. And I tried litigation first, split with banking and finance, which was weird, but again, we won't sidetrack. So I thought I was going to like litigation, but I didn't like it as much as I thought I would. I enjoyed it, but I didn't leave that seat thinking, right, this is where I'll qualify.
Yeah.
And then I did a property seat next, a transactional property seat. And I absolutely loved that, which I didn't think I would. Because I say I didn't enjoy it massively in university, although I did really well in it. So I finished the real estate seat. I was like, oh gosh, what am I going to do? And there was one associate in our office who did real estate disputes, so it was a property litigation. I hadn't given it much thought previously because he was a standalone associate. They didn't offer a seat in that department. But once I knew I loved litigation and real estate, I was like, I really need to try this seat with these two areas. So I fought for it quite a bit, bent the year on a few partners, kept on at our early careers team, and lo and behold, they did create a seat for me in the Manchester team.
Yeah.
And within 2 months, I was saying to my supervisor, this is it, I need to qualify here. And I did. I actually qualified early, so had time to count, qualify within that team, and never looked back. Practiced in property litigation happily for 4 years thereafter.
Brilliant. Amazing.
So yeah, I think it's kind of circumstantial how I ended up there, but also naturally that's where my skill base led me to. I was good at it right back from the university days, so I think it was probably meant to be.
Yeah, I'd agree. Probably the same story with me, meant to be. So I did my law degree, finished my bar course, didn't have pupillage, and the terms of the commercial loan for the bar course are you have to start repaying 1 month afterwards. So I was like, I need a job. Saw a local firm advertising the paper, wrote to them, got the job. I was like, obviously didn't say it to them, but basically I needed money.
Yeah.
So I gladly took my minimum wage job. I was like, yeah, I can start paying my bar course back. Just so happened that was in personal injury, which was super hot at the time. This was pre-LASPO. So there was so much money in that industry, so much work there. So pretty much everyone ended up as a paralegal. I think you're the only person I know who didn't paralegal PI, to be fair.
There we go.
Pretty much everyone else did. It was just where the work was. In a weird way, though, it did quite fit for me because I kind of, I was speaking last time about whilst I was on the bar, I went through this phase of wanting to be a chancery barrister. I think towards the end I realised I wanted to do sort of a common law practice, so PI, crime, that kind of thing. And I think I mentioned this last time. What I like about PI is it's very fact-based. When, lots of these cases go to trial, and there's a lot of sort of transferable skills between PI and crime. So it's all about why did this happen, how did this happen.
Yeah.
It's very much people-based. Anyone can be involved in an accident, anyone can be accused of a crime, so you're going to deal with a broad cross-section of the public. So a lot of transferable skills. So I thought, well, this is going to set me up well for sort of a common law practice. So got that job. And ended up working in PI for several years. And then a few years, I'm not going to go through my full story, but a few years down the line, I decided to hedge my bets, do an LPC and take whichever came first, training contract or pupillage.
Yep.
Lo and behold, a criminal firm were advertising for training contracts, put an application in, invited for interview. The interview went brilliantly. So yeah, got my training contract in crime, got my higher rights during my training contract, did lots of advocacy whilst I was working in that firm. Then during lockdown, the opportunity occurred for me to move across to the CPS. And I should say, I realised at this point that I loved crime so much that I thought, well, do you know what? Even if I went to the bar, it's just crime for me. It's all I want to do.
Yeah.
So although I'd thought previously about some sort of common law practice, I realised, no, crime's my speciality. That's what I want to do. And then last year, made the decision to move across to the bar. So that's how I ended up there. Basically paralegaled in PI for a few years. And then ended up with a training contract in crime. Yeah,
so quite circumstantial for you then as well.
Well, that's it. I mean, because if it wasn't for that advert coming up, I'd have probably ended up carrying on working in one of those firms, would have probably got a training contract with a PI firm, and then would have probably ended up
crossing over to be a
civil barrister or something.
Wow.
No, imagine.
Can't imagine you as a civil barrister.
No, don't get me wrong, there's nothing wrong with it, but could you imagine me not speaking to juries, just doing very formal submissions to judges in the county court? It'd be a very different style of advocacy for me, wouldn't it? So, yeah, I think I've definitely sort of found my wings in the Crown Court, and that's where
I think so.
Yeah, really let myself loose. So so who knows what could have happened?
And I think that's probably true for a lot of people. You find your area by circumstance, and
it's all pure chance.
So that's the reason why we say, don't we, keep a real open mind, because you never know when you're going to fall somewhere and think, gosh, I found my feet here, this is what I want to do.
Yeah.
Or like you in PI, you might think, this is good enough, I could see myself practicing here. And then years down the line, you think, actually no, and you change and go somewhere else.
Keep an open mind, so you're always going to have opportunities. So, you might be in a firm and you might do one area of law, and an opportunity comes up to do a piece of work in something else. Take it. Have a go, because you just never know.
Yeah.
So, for example, to give an example of that, when I was in paralegal in a pretty big PI firm, and there was a chap that came across, and he brought some work with him. He had a bit of a commercial caseload as well, and did a little bit of claimants and a little bit of defence commercial work. I said, I'm going on holiday, I've got this hearing in relation to this commercial case, do you fancy doing it, John? I was like, why not? This is when I was paralegal.
Yeah.
It would have been a CMC or CCMC or whatever. But I was like, yeah, why not? Let's give it a go. So a chance for me to try some commercial stuff. It would have been very easy for me to say, no, it's outside of my area of expertise. I don't know anything about this.
Yeah.
And, quite enjoyed it. But the point I'm making is, opportunities, if they come up, take them, because you just don't know.
No.
You might think, oh, do you know what? I found something I absolutely love. Let's jump in on this.
Mm-hmm. There we go. That's our Ask Speed Squad segment.
So, we watched the film the other day, didn't we, Hayley?
We did. It was called The Runaway Jury.
Indeed.
It was really good. It's probably a quite old film.
I reckon that must be about 20 years old. That
Yeah.
film may be older. Mm-hmm. John Grisham one.
Yep.
So, for those who don't know, John Grisham was a lawyer and now writes crime novels or legal novels. There's loads of them. They're brilliant.
Didn't we say ages ago we were going to get through all of his films?
I think so.
And I think this might be the second one we've watched. Because The Time to Kill was him, wasn't it?
Yeah.
And now this one.
Yeah.
So we're doing very, very poorly at that.
Yeah.
At that resolution.
Films,
There's loads more, because we said we were going to watch them all.
Yeah. We said we were going to watch all the Mission Impossibles, and we're only up to the third one.
Yeah.
Have we finished that one yet?
No.
I
think we got 20 minutes in. We watch films like a series, don't we? So we'll get an hour in or something. We'll go, oh, should we go read for a bit now? Let's go for a walk now. It's very rare that we'll sit down for 3 hours and watch a film start to finish. Although we did with The Runaway Jury. We did watch that all the way through.
Didn't we? Yeah, 2 hours. That's bizarre for us to sit down and watch a film in one go. But yeah, no, it was interesting.
Really
film,
good, yeah. So for those of you who haven't seen it, without giving away any spoilers, it's basically about the jury system and a really high-profile trial in America, isn't it?
Yeah.
So John and I were talking about how different the jury selection is between America and the UK. So over there, it's this complex operation. I don't know if it's quite how it is in that movie.
Pretty much, yeah. So, because I've watched a few of these, I think they call it the voir dire process out there. So what will happen is, you'll have a pool of potential jurors. I think both sides can put questions onto a questionnaire. They'll go out to the individuals, they'll fill out, the potential jurors fill out the questionnaires, and so they're asking for their views on certain things. And then at the hearing, a juror will go in the witness box and give evidence and they'll be questioned by both sides. And then what they can do is, once they've answered the questions, if neither party objects, then that person becomes a juror. Mm-hmm. If either party has an objection, they say, well, do you know what, I'm going to challenge for cause, you're not in. But I think there's a limitation on how many challenges each side can. It'll be different from state to state.
That was in the film, definitely. Yeah. So I suppose it's quite a tactical exercise then, isn't it? I mean, let's just say someone was being prosecuted for...
Let's say a shop theft.
And
there's a shop owner.
Yeah, so there's a shop owner. So the person that's trying to defend them would obviously be like, oh, get rid of the shop owner.
Yeah.
Or someone else who's been convicted of shop theft 10 times. Maybe the prosecution's going to think, he might be sympathetic to the defendant, let's get rid of him.
Yeah.
So it's a real tactical exercise, isn't it?
Absolutely.
But I imagine the overall reason for it, and probably the main aim that it does achieve, if it must give you a relatively neutral jury
That's probably
because
the idea, isn't it?
we just gave 2 crazy examples there, but there's no way the prosecution wouldn't object to that one, and there's no way the defence wouldn't object to that one. So it must be really rare that someone sits on the jury that is that biased towards the case.
You think so? I mean, once again, I don't know enough about it. It could be.
Yeah, I'm just hypothesising, but I imagine that's the reason why they allow it to happen.
That's the idea. So that in theory, you've got someone who's kind of bang in the middle, no extreme views one way or the other.
Yeah.
So that hopefully you should be fairly neutral.
But it's not like that over here, is it?
No. So it's fairly straightforward. So as long as you're on the electoral roll, you may randomly get your letter in the post. You come to court, and then when you're on your 2-week jury service, you hang around. When a trial's ready, you'll be brought into court. And so, for example, it could be 15, maybe 20, go into the courtroom. The court associate will have cards with everyone's name on, shuffle them, first 12 names they read out, go in the jury box.
I imagine there's got to be some restrictions, like if you knew the defendant or if you knew the barrister, etc.
So what they'll do is... the names of all the witnesses in the case will be read out to the jurors. The defendants normally will be asked to stand up, turn and face the jurors, just so they check they don't know them. Obviously the same with counsel and the judge. So if any jurors know anyone within the case, or if anyone knows any of the jurors, then obviously they can't be on the jury. So yeah, but that's about the extent of it, and it's a fairly quick process.
There we go.
But yeah, it's interesting the differences in the system, isn't it?
Yeah, really interesting. And if you haven't seen The Runaway Jury, we would definitely recommend it. It's a really good film.
It's a good film.
So shall we stick with our courtroom theme? I think you've got an interesting tale to tell, haven't you?
Certainly have, yeah. A case that occurred recently. So I was representing a chap, and it was a multi-handed case.
I'm going to tell the audience what that means.
So that means that there are more than one defendant.
Remember the first time you said that to me, and I was like, "What?"
He's
like multi-hander.
It's a 3-handed robbery. What? How's he stolen with?
Yeah, it was that. And then when you said to me, bender, he's got a bender. Like, what? What's that? That's a suspended sentence for those who don't know.
Yeah. We have our own court slang.
Yeah.
So multi-hander, and anyway. Morning of trial, my chap didn't turn up. Obviously go into court when the matter was listed, bring the matter before the judge, and I had to explain to the judge that my chap wasn't there. So the judge issued a warrant not back for bail, meaning that there's a warrant out for his arrest and for him to be brought to court. Mm-hmm. And so what he did was he said, well, we'll adjourn this off until after lunch. We'll see if he rocks up. If so, then obviously we can deal with the warrant then, and then hopefully get the trial up and running. If he's not, then we'll adjourn overnight, and then the prosecution would have time to draft a written application to proceed in his absence, meaning if this particular defendant didn't rock up the following day, or hadn't been found, didn't turn up, and the prosecution's application was granted, they could then proceed in the absence of the defendant. Mm-hmm. Pretty difficult to win a trial when you've got no client there.
So in that scenario, John, the warrant's out for his arrest.
Yeah.
They still don't find him. They can't produce him at court. What do you have to do as the barrister?
Okay, so it all depends on whether you're fully instructed. So if your client has served a signed defence statement, if you've got a signed proof of evidence, so the proof is, it's almost like a witness statement from your client, but it never gets served on the other side. It's just his instructions as to what his case is. So as long as you're fully instructed in that regard, then in theory you know what his defence is, and you can continue to represent him in his absence, maybe put questions to the witnesses, and of course give some form of a closing speech. If you're without instructions, so if you don't have a signed proof nor a defence statement, you have to withdraw.
Oh, okay.
So it all depends on whether you've got instructions or not, but if you're without instructions,
you have to withdraw.
You have to withdraw.
Wow, there we go.
Yeah, absolutely. So a bit of an interesting scenario. Mm-hmm. Yeah. Okay.
On a very related subject, Katie Price apparently has a warrant out for her arrest right now.
Oh, really?
Because she didn't turn up to bankruptcy proceedings or something.
Wow.
Yeah. I think, this popped up on my Twitter feed, so we'll say that with a pinch of salt. I think that's true.
Yeah.
It might not be. So, what's next, John?
Well, we'll move on to the legal section.
Okay.
And you were talking a little bit about juries. So I thought I'd explain how a trial works in the Crown Court. So this is a criminal trial in the Crown Court. So we mentioned juries. Obviously, you have a jury in the Crown Court. So what will happen is, first things first, the jury needs to be sworn in. The judge will give an initial opening to the jury just to tell them what their role is in this, and basically tell them not to conduct any additional research about the case and to judge it purely on the evidence. Then hands over to the prosecution to give an opening speech. From there, the prosecution then start to present their case. So they call witnesses into the witness box. So one by one, a prosecution witness will go into the box. For each witness, the prosecutor would ask a series of questions of that witness for them to tell their story. That's called evidence in chief. Mm-hmm. And then the defence have the opportunity to cross-examine. So if it's a single defendant, then one barrister would cross-examine. Obviously, if there are multiple defendants, then one by one, the defence counsel have the opportunity to cross-examine. And the same process occurs for each and every witness. If there are any witness statements that have been agreed, because sometimes it might be that there's a witness that's to give evidence, they produce a statement, but nobody has anything that they want to challenge that witness on. Yep. The statement will be agreed, so that statement will be read out. Sometimes evidence can be pre-recorded, so if you've got particularly vulnerable witnesses, children or other individuals, they might have had their evidence pre-recorded, so that would simply be played to the jury. Mm-hmm. Then at the end of the prosecution's case, if there are any agreed facts, the prosecutor would read those agreed facts out to the jury. And that's the prosecution case. Mm-hmm. Then it's the turn of the defence to present their case. So the same process. So let's just take a single defendant trial just to make life easy. Normally the defendant will go in the witness box first. No hard and fast rule saying that, but as a general rule, you'll call the defendant first. So the defendant will go in the witness box, they give their evidence in chief, and the prosecutor can cross-examine. Then likewise, if there are any other defence witnesses, they will go into the witness box one by one. And then that effectively concludes the evidence. The prosecutor would then give a closing speech. Mm-hmm. The defence barrister will give a closing speech. The judge will give directions to the jury, so directions on the law and what their duties are. Normally they'll give what's called a route to verdict, so effectively they'll simplify the legal principles that the jury have to consider into a series of questions. If yes, then move on to this question. If yes, move on to this question. If yes, move on to this. So it simplifies the law for them. And then away the jury go to deliberate. So at first, the jury will be asked to give a unanimous decision. So the judge will say, you may have heard of majority verdicts. Don't worry about that. All I care about is a unanimous verdict. That's all I want. If I'm going to ask for a majority verdict, I'll tell you at the right time. But for the time being, unanimous only. Then as time goes on, if the judge is happy for a majority, I'll tell them, and they go from there. So that's a trial in the Crown Court. Wow.
And if, like me, you were really interested by that explanation and you fancy having a go at a criminal trial yourself, you can join us at the Advocacy Club, because over the next 3 months, we'll be conducting our very own criminal trial. So by the time this episode airs, you will have missed the opening speech that's taking place tonight, the 30th of July. But never fear, there's still time for you to take part in the witness handling session, which will be in August, and the closing speech session, which will be in September.
Yeah, precisely.
So if you want to sign up, go to speedmooting.com/advocacy-club.
That's the one. Now, speaking of law and the legal aspects, we'll move on to Commercial Awareness Corner.
Okay.
And do you want to talk to us about how people bill in the civil world?
Sure. The trials and tribulations of commercial billing.
Fun.
Very fun. I think I would hazard a guess as to say I think 90% of commercial solicitors will probably tell you that the bane of their existence is time recording, but it's the model on which the industry is built, so it's something that we all have to stomach and get through. So if you get to grip, the sooner you get to grips with it, the happier everyone will be. So in a nutshell, you record your time via units. So 1 unit is 6 minutes. 10 units is an hour.
Right.
So everything you do, if you answer an email and it only takes 2 minutes, doesn't matter, you log a unit and that equates to 6 minutes of your time. And why it's really important is that you will have an hourly billing rate. So if your hourly billing rate is £300, once you've logged an hour, that's £300 worth of WIP, which is what we call work in progress. And how this all fits together is when you are doing a piece of work for your client, you either give them a fixed fee or an estimate of how much time you're going to spend and how much it's going to cost them. So I may say to you, John, okay, I'm going to draft this particulars of claim for you. I think it's going to take me an hour and a half. That's going to be an estimate of £500. And that's based on me only having to do 2 drafts. That's based on me only having to email you a couple of times for your approval. That's based on X, Y, and Z. So you'll scope out the piece of work that you need to do. And that's really important because a lot of the time you get to the end and here's the particulars of claim and you look at your clock and think, okay, I spent 3 hours. So there's a difference, as I say. If it's an estimate, then there's more of a scope to go to the client and say, okay, we've overrun a little bit here. We've actually incurred £600, £700, whatever it might be. The reason there's an overrun is because, if you remember, I said there was only going to be 2 drafts. It actually took 6 drafts because you gave me new information and new evidence here, and here. So let's, meet in the middle. We'll bill this much. You're paying a bit more than you estimated. We're losing a bit of money, etc. If it's a fixed fee, then there's usually not as much scope for negotiations in that way, unless it's wildly outside the scope. And that's why it's really important, and you'll learn this as a junior, that you are really, really strict and regimented when you give your client scopes and estimates.
Yeah.
It helps with the recovery process at the very end. Now, sometimes a lot of firms have standard fixed fees for different areas of work that they do. So when I worked in mortgage repossession, for example, a lot of it was volume-based work. So it would be £100 once you do this, £200 once you do this. And that works fine with the volume-based stuff.
Yeah.
And then generally, if somewhere down the line, the powers that be, so this is the partners, the directors, think, we're actually losing a bit of money, we're not making profit on this area of work, then that's a bigger problem in terms of pricing. That wouldn't be down to the juniors. It wouldn't be their fault, as long as you're time recording properly. So if it's taking you 2 hours when they thought it's only going to take an hour, then that's a pricing problem for the partners and the directors to fix. When it's really important for a junior is when you're dealing with your own scopes and your own estimates. But the biggest, most important thing for juniors is just time recording accurately. So you'll be trained very, very early on. Don't self-edit your time. Make sure you record absolutely everything. If you're thinking about a case on the way home, you should record some time. If you think about a case in the shower, you should. If it's something that's progressing the case, record.
Yeah.
You don't always bill the stuff, when you're back and forth with your supervisor and they're giving you supervision or they're mentoring you. You'll record it, but then when you get to the end, as a junior, that's when you'll go sit down with the partner and say, this is all the time on the clock. How much can I bill the client?
Right.
So you've always got to do the right thing by your client. And as a junior as well, particularly as a trainee, it's accepted that a big, big, big chunk of your time will be written off, and that's down to training, and that's absolutely fine. We could talk about time recording for about 2 hours, I think. There's a lot of opinions about the time recording model out there.
Yeah.
We won't get too opinionated on this podcast.
No.
We'll just keep it simple. You're recording units, 6-minute units, and you have to record absolutely everything you do in commercial firms.
Wow.
Any questions?
Not really. I'm just glad that whenever I've done privately funded work as a solicitor, it was always on a fixed fee.
Yeah. It's nice.
So, this weekend, Hayley, we are off to a car festival, or car and music festival, aren't we?
Yeah, it's going to be really fun. So this is for your birthday.
Yeah.
So John's birthday is the 8th of August. Sure you don't mind me putting that out there on the air?
Why not? Greatest day of the year.
Yeah, so if anyone doesn't know, John is a huge car fanatic,
I would say
car?
so.
Yeah.
I would say so.
So, I think in the almost 6 years I've known you, I think there's probably been 1 or 2 times I could ever recall where a car's driven past and you've not been able to say, "That's a Dodge Ram Charger, 2 turbo, duh."
You've combined 2 different Dodge cars, but fair enough, yeah.
You get the point, yeah. John knows his cars very, very well, does motor and sport in his spare time, so that's kind of where your love and hobbies lie.
Absolutely.
So what better way to celebrate another year of John Dorf by going to a car and music festival?
Oh, it's going to be insane, isn't it?
It's going to be fun.
Be drag racing there, flamethrower contests. So, people who've got these exhausts that shoot flames, they're going to have contests.
Yeah.
Betting out contests.
What's a betting out contest?
Well, we call them wheel spins in this country, to be fair.
Right.
So when you get whichever are the driven wheels, the front or the rear, whichever type of car you got, and they just spin. I don't know if it's going to be who can make the most smoke or what have you.
Maybe.
There's like a little time attack track as well, so a little mini track made out of cones. I imagine there's going to be lots of people with subwoofers in the cars playing loud music. It's just going to be...
It's going to be fun. And there's also going to be lots of food and food festivals on, and then music in the night, so it's like Creamfields but with cars.
Pretty much, yeah.
I've never been, you've never been, so we're imagining what it's going to be like.
What I imagine it's a bit like is if you ever saw the first Fast and the Furious film and they go to race wars.
Which bit's that?
So towards the end, when they go to that place in the desert and everyone's there, they're all staying over in the little caravans and stuff, and then there's loads of people with cars and they're doing a bit of drag racing.
Yeah.
I imagine it's a little bit like that, but a British version.
Maybe.
Yeah.
Well, watch this space. We'll tell you all about it on next week's episode.
About it next week. We'll ask Hayley which was her favourite car that you saw there.
Yep.
So it's going to be good anyway. So we'll tell you all about that next week.
Yep.
And I think that brings us towards the end of another episode.
I think so.
So I've enjoyed recording it. Hayley, have you?
I have, John.
I hope you guys have enjoyed listening. And if you're still listening, comment straight pipe exhaust.
That's a bit of a hard one.
Alright, we'll just comment.
Comment Dodge Charger.
Dodge Charger, okay.
Is that a car?
That's a car.
Yeah.
That's Dominic Toretto's car.
That's why I know it.
Dominic
Toretto.
Dominic Toretto. You don't know me. You're about to.
So much torque, the chassis twisted.
So much torque, the chassis twisted coming off the line.
Yeah, Dodge Charger is the word.
Dodge Charger, okay, yeah. If you're still listening, comment Dodge Charger. That brings us to the end of another episode. We will see you next week for episode 19. If you know who that episode is going to be named after as well, comment below.
And don't forget to like, comment and subscribe.
Of course. And we'll see you next week.
Bye.
Bye.